Hi, I'm Brad Rowe with Rowe Law Group, and today let's talk about domestic violence injunctions. So, you got served with a restraining order, or you're thinking about filing one. Either way, there is a hearing coming, and most people show up completely unprepared. Here's what you need to know. In Florida, a restraining order is also called an injunction for protection. Domestic violence injunctions are governed by Florida Statute 741.3. To qualify, two things have to be true. First, the relationship. Have to be in a family or household members, spouses, ex-spouses, people related by blood or marriage, people who live together or used to live together or have a child together. Roommates you found on Craigslist do not count. Neighbors don't count. If the relationship doesn't fit, you may be looking at a different type of injunction. Stalking, dating violence, repeat violence, each has its own set of rules. With domestic violence, it comes with assault, battery, stalking, kidnapping, false imprisonment, or any criminal offense resulting in physical injury or death, or a reasonable fear that you are in imminent danger of becoming a victim of one of those acts. It does not have to be physical, but it does have to be more than we argue a lot. The petitioner files a sworn petition at the courthouse. The judge reads it. If the judge finds an immediate and present danger, they enter a temporary injunction. It's good for up to 15 days, and it's in effect the moment the respondent is served. That temporary order can remove you as a respondent from your home, restrict contact, and require you to surrender firearms and ammunition. The final hearing typically happens within 15 days, and this is the real thing. Both sides appear, both sides can testify and call witnesses, present evidence like texts, videos, medical records, recordings. The petitioner has the burden of proof by preponderance of the evidence. That means it's more likely than not. An injunction is a civil order and not a criminal conviction, but the consequences are very real. You lose your right to firearms, goes into a statewide database that law enforcement can see. This can affect employment, professional licenses, and even immigration status. It can shape a custody case. And violating that injunction, even by sending one text message, can be a misdemeanor or a felony if it happens enough times. A final injunction can last a set term or even be permanent. Two things people get wrong. They think when the petitioner files the paperwork, the job is done. They still have to prove it at a hearing. Respondents think they can just show up and explain. You can't do that. Your hearing is your one shot, and that record follows you. Either way, don't walk into that courtroom alone. Brad Rowe, Rowe Law Group, Pensacola. If there's a legal topic that you would like some information on, drop it in the comments below. I'll read